Labor Law of Cambodia, 1997, Lapse of lawsuits for payment of wages, guarantees and priority of wage claims, wage deductions, garnishment and assignment of wages of workers and domestics, supervision and distribution of tips. D. Lapse of lawsuits for payment of wages. Article 120, a lapse of a lawsuit, the statute of limitations, for the payment of wages is 3 yeas from the date the wage was due. Claims subject to the lapse of lawsuit include the actual wage, perquisites and all other claims of the worker resulting from the labor contract, as well as the indemnity in the event of dismissal. E. Guarantees and priority of wage claims. Article 121, amounts owed to contractors of any kind cannot be garnished nor can payment be objected, stopped, with prejudice to workers' wage payments. Wages owed to workers shall be paid before payment is made to suppliers of supplies used for construction. Article 122, wage claims of the workers, including domestic or household servants, shall take priority over the movable or immovable properties of the debtor within the last 6 months prior to the declaration of bankruptcy or the court-ordered liquidation of the employer. Sales agents and commercial representatives have priority for commissions and remittances earned for the last 6 months prior to the declaration of bankruptcy or court-ordered liquidation. Priority established by this article also applies to the claims of workers for paid holidays and compensation for notice period and to dismissal indemnity. Article 123, prioritized claims provided for in Article 122 above, are opposable to all other general and special priority, including the priority of the National Treasury. Amounts deducted by the National Treasury from the money order of the employer after the date when payment of debt was stopped shall be returned to debtors, subcreditors. Article 124, workers benefit from outclassing all creditors for a portion of their claim, the unmatchable portion of wages earned by laborers during the last 15 days, by employees during the last 30 days, and by commercial representatives during the last 90 days prior to the declaration of bankruptcy or court-ordered liquidation. This part of their claim is paid to the workers before other claims, just within 10 days following the declaration of bankruptcy or court-ordered liquidation by a simple ruling of a judge, from the funds existing at the time the bankruptcy was declared or the liquidation was ordered, or from the first funds that become available. Article 125, in order to determine the amount of wage in view of enforcing the provisions of Article 124 above, not only the actual wages are taken into account but also the other items of remuneration covered in Article 103 of this law, as well as any damages due eventually for the breach of contract. F. Wage deductions. Article 126, wage deductions for the purpose of job placement that are provided directly or indirectly to an employer, to his representative, or to any intermediary such as a labor recruiter are prohibited. Article 127, none of the balance can be made, in favor of the employer, between the worker's wage and the employer's claim for diverse supplies of whatever kind, with the exception of 1. Tools and equipment required for the work and that are not returned by the worker upon his departure. 2. Items and materials under the control and usage of the worker. 3. Amounts advanced to acquire the said items. 4. Amounts owed to the company store. However, the total amount deducted from the wage, in any case, cannot surpass the portion deemed necessary to provide basic living for the worker and his family. Article 128, any employer who makes a cash advance, other than the amount advanced for the purchase of tools, equipment, items and materials that the worker takes charge of and uses, can get reimbursed only by a series of gradual deductions that do not exceed the transferable or attachable portion of the wage. The deducted amounts are not to be confused with the attachable portion of the wage as determined by laws in effect. The employer has the priority to deduct this attachable portion before a third party to whom the worker owes installments as stipulated in Article 116 above, and partial wage payments made before the normal deadline but in payment for finished work can be fully deducted from the following paycheck. Article 129, Collective agreements authorizing any wage deductions other than these cases are null and void. However, the worker can authorize deductions of his wage for dues to the trade union to which he belongs. This authorization must be in writing and can be revoked at any time. G. Garnishment and assignment of wages of workers and domestics. Article 130. Wages can be garnished or assigned only as follows. 1. The portion of wage that is less than or equal to the guaranteed minimum wage cannot be garnished or assigned. 2. A maximum of 20% of the portion of wage greater than the guaranteed minimum wage to 3 times the minimum wage can be garnished or assigned. 3. A maximum of 30% of the portion of wage greater than 3 times the guaranteed minimum wage to 10 times the minimum wage can be garnished or assigned. 4. A maximum of 50% of the portion of wage greater than 10 times the minimum wage can be garnished or assigned. The wage taken into account for this calculation is the monthly wage. Article 131. The limits, stipulated in Article 130 above, do not apply to food creditors, since the purpose of the unattachable portion of the wages is to feed the worker's family. However, food creditors can only claim the current monthly amount of his ration allowance. For overdue amounts, they must participate with the other creditors for the attachable portion. Article 132. Family allowances cannot be garnished or assigned except to pay for debts for food. Article 133. The garnishment and assignment of wages are to be carried out in accordance with the procedure of law in effect. H. Tips. Supervision and distribution of tips. Article 134. Tips are remuneration made by clients to personnel of certain establishments such as hotels, restaurants, cafes, bars, and hair salons, and received by the employer as a mandatory percentage added to the client's bill with a note service charge. These tips must be collected by the employer and distributed in full to the personnel in contact with the clientele. Article 135. The employer shall clearly justify the receipt and the payment to his staff of the amount of tips covered by the preceding article. Article 136. The method of dividing tips and determining the categories of personnel who should receive them are established by the customs of the occupation or, if not applicable, by a procas, ministerial order, of the Ministry in charge of labor.